Chapter 3, Creditors' Remedies, SS 51, Concurrent Remedies. Legal and equitable. Equity has concurrent jurisdiction with law over frauds under the Statute 13 Alis, C5, or similar enactments, and the same general rules of construction govern in both courts. Thus it was remarked by the Supreme Court of New Jersey, courts of law and courts of equity have concurrent jurisdiction over frauds. Under the statute concerning fraudulent conveyances, in cases where the legal title to the property is such that it cannot be seized under execution, resort to equity is necessary. As where the legal title has never been in the debtor, having been conveyed by a third person directly to another, in secret trust for the benefit of the debtor, with a design fraudulently to screen it from his creditors, but where the legal title has been in the debtor, so as to be subject to execution at law, and might be made available for the satisfaction of the debt. If the fraudulent conveyance had not been interposed, the creditor, or a third person having taken title under a sheriff's sale, may bring ejectment and avoid the fraudulent conveyance by proof of the illegal purpose for which it was made. It will be presently seen that this latter illustration is not of universal application. The forms of relief available to creditors are outlined in our opening chapter, where it is shown that creditors may invoke the aid of equity in two cases: after proceeding to judgment and execution at law without obtaining satisfaction of the debt. In the first class of cases, the complainant proceeds simply upon the ground of fraud, and in support or furtherance of the remedy at law, while in the other class of cases relief is sought upon the theory that the remedy at law has been exhausted, and that it is inequitable and unjust on the part of the debtor to refuse to apply any intangible property or choses in action toward the payment of the judgment. Resort by creditors to courts of equity is a very frequent occurrence because the common law is not sufficiently flexible, of necessity. In a common law action, a purchase is treated as either valid or void. There is no middle ground. Proof of absolute fraud, which is usually difficult, is for that reason generally required at law. While in equity it is said that an unfair or inequitable transaction, one not of necessity absolutely fraudulent in the full sense of that term, may be unraveled in the interest of creditors. In such cases, the rights of an innocent vendee can be preserved and protected by the plastic hand of equity. In other words, certain cases seem to imply that proof of fraud need not be so complete in equity as at law. But it is not so easy to illustrate the distinction of to state a substantial justification for its existence. Mr. Abbott observes in an editorial in the New York Daily Register, in the quaint language of Westminster Hall, illegal fraud means illegal fraud, that is to say, fraud for which an action at law lay to recover damages. So equitable fraud means inequitable conduct, not illegal in the sense of sustaining an action for damages, but yet so like it in effect that the Chancellor would give a remedy, though in some states legal and equitable jurisdictions have been united in the same tribunals. Yet the distinctions which formerly appertained in the forms of action, of pleading, and of relief are by no means superseded or obliterated in territory where the system of common law and chancery both prevail, and the only adequate relief is in equity, and the pleadings are framed in accordance with this view. The suit must be tried as a chancery case by the modes of procedure known to courts of equity. The judge or chancellor is responsible for the decision, and, though he may, by means of feigned issues, refer any questions of fact to a jury, still his own conscience must be satisfied that the finding is correct, and the decree must be rendered as the result of his individual judgment, aided, it may be true, by the finding of the jury. Hence, where the trial in such a case is conducted as though it were a controversy in a common law action, and a judgment is rendered upon a verdict as at common law, it will be reversed for error, and in an equitable proceeding of this character, as will presently be shown, a decree in the nature of a judgment for damages cannot be rendered against the defendant who is alleged to have fraudulently taken an assignment of the insolvent's property. The decree must be for an accounting as to the property which has come into the hands of the fraudulent vendee, where property which is legally liable to be taken in execution has been fraudulently conveyed or encumbered. The jurisdiction is usually concurrent, as the creditor may either issue an execution at law and sell the property, or file a bill in equity to have the conveyance set aside. The remedy in equity, as will presently appear, is necessarily exclusive in cases where the subject matter of contention is not subject to execution. SS 52. No injunction against debtor before judgment. As a general rule, a simple contract creditor who has no lien on the property cannot enjoin his debtor from selling it, nor will he be allowed to come into equity to invoke its interference to preserve the property until a judgment can be obtained. If the property of an honest, struggling debtor could be tied up by injunction upon mere unadjusted legal demands, he might be constantly exposed to the greatest hardships and grossest frauds, for which the law would afford no adequate remedy. It would deprive him of the means of payment, or of defending himself against vexatious litigation, and force him into unconscionable compromises to prevent the ruin of his business pending the controversy. An injunction ought not to issue to compel parties to hold goods pending a trial at law with the expectation that they may be wanted to answer in execution upon a judgment which the creditor hopes to obtain. The authorities are clear, says the learned and lamented Mr. Justice Campbell, that Chancery will not interfere to prevent an insolvent from alienating his property to avoid an existing or prospective debt, even when there is a suit pending to establish it. The reason of the rule, says Chancellor Kent, seems to be that until the creditor has established his title he has no right to interfere, and it would lead to an unnecessary and, perhaps, a fruitless and oppressive interruption of the exercise of the debtor's rights. Unless he has a certain claim upon the property of the debtor, he has no concern with his frauds. So the simple contract creditors of a firm ordinarily have no specific lien upon the firm property which will enable them to interfere with any disposition which the firm may make of it. SS 53. Certain exceptional cases. Occasional exceptions may be found in some states to the rule that equity will not interfere at the instance of a simple contract creditor, but the exceptions prove the force of the rule. In Moore v. Kidder, the bill distinctly charged a fraudulent intention on the part of a debtor summoned as trustee, and an attempt to dispose of his property and put it beyond the reach of creditors, for the purpose of defeating the plaintiffs in the collection of any judgment that might be obtained in a suit at law, and asked for an injunction to prevent that mischief and wrong. The court said that the bill very clearly showed a case for equitable interference in aid of the remedy at law, and that without such relief the suit at law would be rendered fruitless by the active fraud of the defendant. Clearly this was a proper case for the issuance of an attachment or other suitable provisional relief in the action at law. In another case where a bill charged insolvency in the debtor, and averred that he had fraudulently transferred his goods to a third person who was implicated in the fraud, and that the debtor had purchased the goods with intent to defraud the plaintiffs, a receivership was allowed before judgment. Here the relief was extended upon the theory that the goods for which the indebtedness was created were fraudulently obtained, and that the debtor never acquired title to them. This would seem to be substantially substituting a bill in equity for the relief usually incident to replevin. These cases can scarcely be commended as safe precedents. SS 54. Joinder of claims. The assets of the fraudulent debtor are, as a rule, scattered among different friends, in different forms, and by transactions had at different times. This requires us to notice the authorities as to uniting or joining claims. In cases where the sole object of the bill is to secure satisfaction of a judgment out of property fraudulently alienated, the suit may be framed to avoid several distinct conveyances made to as many grantees. Such a bill is said to embody a single cause of action. This principle applies although the defendants may have separate and distinct defenses. In Latin v. McCarty, it was decided that an equitable cause of action to cancel and remove, as a cloud upon plaintiff's title, a deed given by mistake by a third party to the defendant, under which the latter had fraudulently obtained possession, could be united with a claim to recover possession of the premises, and asserted in the same complaint. The principle of this case was expressly repudiated in Missouri in an action involving substantially the same state of facts, on the theory that a bill in equity was not a proper form of action for the recovery of the possession of real estate, there being an adequate remedy at law. But this latter reason does not commend itself as conclusive. Fraudulent confessions of judgments entered in different courts may be attacked in one suit, so a partner may sue his copartners for an accounting, and may join in the same action alienees of his copartners, to whom the latter have collusively transferred partnership assets in fraud of the partnership, and seek a cancellation of the transfer as well as an accounting. Why? It has been said, should not all this be embraced in one action? The object is single, viz., to bring about a complete and final settlement of the partnership. SS 55. Uniting causes of action. Questions relating to the joinder of causes of action of necessity frequently arise for adjudication in contests of the class under consideration, where debtors have sought to conceal property by different subterfuges. In Palin v. Bushnell, the plaintiff, as receiver in supplementary proceedings, instituted an action against the debtor and a third party to recover monies usuriously exacted by the third party from the debtor, to compel the third party to account for securities belonging to the debtor, and, to set aside as fraudulent certain transfers of real and personal property alleged to have been made by the debtor to the third party. The court observed, "What is the subject of the action in this case? It is the restitution of the property of the judgment debtor whom the plaintiff represents, to entitle himself to this relief. The plaintiff avers in his complaint different transactions out of which his right to restitution flows." This statement is criticized by Mr. Pomeroy as follows: "There is here a plain confusion of ideas. The restitution of the debtor's property, which is the relief demanded, is the object of the action. If there is anything connected with this matter clear, it is that the authors of the code used the terms subject of action and object of the action to describe different and distinct facts. The criticism upon the particular language employed in this case is probably just, but we cannot suppress the conviction that a system of procedure which prohibited the joinder of such claims in a single action would furnish most unsatisfactory and inadequate redress to creditors." SS 56. Exclusive jurisdiction in equity. Manifestly in cases where property is of such nature that it never was subject to execution at law, the remedy of creditors desiring to reach it, as we have observed, is exclusively in chancery. Thus, as has already been shown, it was observed by Chief Justice Gray, in delivering the opinion of the Supreme Court of Massachusetts, in Drake v. Rice, that, by the law of England before the American Revolution, fraudulent conveyances of choses in action, though not specified in the statute, were equally void, but from the nature of the subject, the remedy of the creditor must be sought in equity. SS 57. Land purchased in name of third party. The creditor may encounter a practical difficulty in reaching realty paid for by the debtor the title to which is fraudulently taken in the name of a third party. This is a very common device. The courts are somewhat at variance upon the question as to whether or not real estate so held can be sold on execution against the debtor and recovered by the purchaser in ejectment, or in fact, whether it can be reached by any proceedings at law. Authorities can be cited to the effect that an execution sale of land, the title to which is held in this manner, passes nothing to the purchaser. The creditor's proper remedy to reach it is declared to be by bill in equity. The grantee is considered to hold the title impressed with a trust in favor of creditors, and may be compelled to quitclaim his interest. The principle embodied in these authorities seems to commend itself as logical, but it is not universally recognized. There are cases holding that an execution purchaser on a judgment against the debtor may recover the lands in ejectment, even though the title was never in the debtor, if it is shown that the fraudulent grantee held it for the debtor's benefit, and that such an interest may be attached. It may be observed that a purchase of personal property by a debtor in the name of a third party does not exempt it from direct seizure by creditors. SS 58. Relief before and after sale. The jurisdiction of a court of equity is ample either before or after sale under a judgment, to set aside a deed made in fraud of creditors before sale to enable the creditor to present and sell an unembarrassed title, after sale to remove clouds from the title. It will thus be seen how important the jurisdiction of equity becomes in connection with fraudulent transfers. It would often be impossible, especially in cases affecting realty, to render the title marketable until the flexible hand of a court of equity had removed the simulated transfers and encumbrances in which the debtor has involved it. Equity alone can disentangle the title from the doubts and embarrassments which interfere with a realization of a fair price. And to that extent and for that purpose its invaluable assistance is usually asked. In Red v. Hounson, the court said, the bill must be construed in reference to its nature. It is not filed to reach property incapable of seizure on execution, and therefore based on the theory that the legal remedy has been exhausted. Very far from it. The principle on which it proceeds is that a legal remedy is in fact progressing, and which, being fraudulently obstructed, the aid of the court is needed to remove that obstruction. The claim made is that the deed from the judgment debtor to his son is fraudulent as against the creditor, and that the farm is therefore subject to levy and the deed exposed to be removed out of the way of it by the assistant jurisdiction of equity. SS 59. The remedy at law. A judgment. Creditor may proceed at law to sell under execution lands or property which his debtor has fraudulently alienated, which are subject to execution. The attempted transfer may be treated as a nullity, and the property subjected to seizure and sale upon execution the same as though no such covenant transfer had ever been made. The creditor in such cases may consider the debtor as still the owner of the property, and may pursue it to secure satisfaction of the claim the same as though the title were unembarrassed by the fraudulent deed or transfer. This general principle was involved in Rinchi v. striker, in which case it was decided that where an attachment was issued to a sheriff, he was entitled to seize under it any property which the debtor might have disposed of with intent to defraud his creditors, that by such seizure a specific lien was acquired upon the property attached. And the sheriff, when sued for wrongfully taking the property, had a right to show, even before judgment in the attachment suit, that the title of the purchaser from the debtor was fraudulent and voidable as against the attaching creditor. SS 60. By suit in equity, fraud is one of the recognized subjects of equity jurisdiction, and is the most ancient foundation of its power. The existence of a remedy at law does not interfere with the right of a creditor to resort to a court of equity to secure a cancellation of a fraudulent conveyance as an obstacle in the way of the full enforcement of a judgment, and a cloud on the title to the property sought to be reached. The suit in equity is sometimes said to be an ancillary relief in aid of the legal remedy. Since a court of equity does not intervene to enforce the payment of debts, it may be asked why resort is so frequently had to a creditor's bill seeking a decree to avoid or cancel the covenant's transfer when the property may be more expeditiously seized under attachment or execution. The creditor's bill, or a suit to clear the fraudulent transfer, is, for many reasons, entitled to preference as a means of relief. Should the creditor attempt to sell the disputed property arbitrarily under execution, bidders would be deterred from purchasing lest they should buy a lawsuit. Hence, the market value of the land embraced in the covenant's transfer is practically destroyed. Then the seizure of the property subjects the creditor to the peril incident to proving that the transfer was fraudulent, and in the event of failure to establish fraud, of paying damages for the unwarrantable interference, seizure, and sale. By filing a creditor's bill, practically the only risk incurred is the costs and expense of the suit, for generally no seizure is effected unless the suit is successful, in which event the covenant's transfer and cloud on the title is cleared away. Then, as already stated, equity procedure is more flexible than the procedure at law, and in equity an inequitable transaction not absolutely fraudulent in the full sense of that term may be avoided at the suit of a creditor. Fraud, it is said, may be presumed in equity but must be proved at law. But this is a loose and unreliable statement, for it must be proved in either form. Courts of equity, it is true, will act upon circumstances indicating fraud which courts of law might scarcely deem satisfactory proofs, and will grant relief upon the ground of fraud established by presumptive evidence of such character as courts of law would not always deem sufficient to justify a verdict. The Supreme Court of Pennsylvania, in commenting upon the applicability of equity to suits involving fraudulent alienations, remark, it is especially adapted to this class of cases. Its process is plastic and may be readily molded to suit the exigencies of the particular case. A court of equity proceeds with but little regard to mere form. It moves with celerity, and seizes the fruits of a fraud in the hands of the wrongdoer. Having jurisdiction for one purpose, equity will make a complete disposition of the cause. Equity endeavors to deal with the substance of affairs, to look beyond the observance of mere forms, to regulate its judgment according to the real purposes which controlled parties in the various matters brought before it for relief or correction, to tear aside the covering beneath which the perpetrators of the fraud seek concealment, to deal with actual facts, not with pretexts and disguises. The Supreme Court of Illinois say, equity will penetrate beyond the covering of form and look at the substance of a transaction, and treat it as it really and in essence is, however it may seem. Rules of pleading in equity are not so strict in matters of form as at law. SS 61. Supplementary proceedings. Supplementary proceedings have, in New York and in some of the other states which have appropriated its reformed system of procedure, taken, in some measure, the place of creditors' actions or suits in equity to reach equitable assets. This remedy is now a special proceeding in New York, and not a proceeding in the original action. These proceedings furnish, to a certain extent, a substitute for a creditor's bill, for the discovery and sequestration of property, and by their commencement a lien is said to be acquired upon the debtor's equitable assets, though another creditor may gain precedence if, after the service of the order for the examination of the debtor, and before the appointment of a receiver, he discovers property liable to execution and levies upon it. Generally speaking, these proceedings will reach whatever property is available on a creditor's bill, and have, as we have seen, been held to be a simple substitute for it, and are entitled to all the presumptions of regularity which appertain to proceedings in courts of general jurisdiction. Supplementary proceedings are not exclusive. The judgment creditor may abandon them and institute a suit in his own name to annul a fraudulent alienation, if indeed he may not invoke both remedies at the same time. If a third party makes claim to any property which the examination discloses, The rights of the claimants cannot be determined in this proceeding, but resort must be had to a suit. The procedure is usually by order, made upon proof of the return of an execution unsatisfied, requiring the debtor to appear in person in court, to be examined concerning his property. The judgment upon which the order is procured must be in personam, property or equitable assets being thus disclosed. A receiver is appointed, who, upon qualifying, becomes vested with the debtor's assets and equitable interests, without conveyance or assignment, though he does not get title to exempt property. The receiver represents creditors, and thus may impeach the debtor's fraudulent sales in the right of creditors. It seems to be no objection to the exercise of the jurisdiction appointing a receiver that the debtor has no assets, or that such property as he is possessed of is subject to execution. As an illustration of the utility of this remedy, it may be stated that a widow's unassigned right of dower can be reached by her creditors in supplementary proceedings, for it is liable to their claims, and a receiver appointed in these proceedings may bring an action for its admeasurement. SS 62. The Sumsit case. Conspiracy. A fraudulent assignment will not ordinarily authorize a judgment against the purchaser for the original debt, nor is an action on the case considered to be an appropriate form of procedure against the debtor and his fraudulent alienee. The latter form of action is discussed at much length in Lamb v. Stone, and the language of the court is quoted with approval by the learned and lamented Mr. Justice Campbell in Adler v. Fenton, as follows. The plaintiff complained of the fraud of the defendant in purchasing the property of his absconding debtor, in order to aid and abet him in the fraudulent purpose of evading the payment of his debt. The court asked, what damage has the plaintiff sustained by the transfer of his debtor's property? He has lost no lien, for he had none. No attachment has been defeated, for none had been made. He has not lost the custody of his debtor's body, for he had not arrested him. He has not been prevented from attaching the property, or arresting the body of his debtor, for he had never procured any writ of attachment against him. He has lost no claim upon, or interest in the property, for he never acquired either. The most that can be said is that he intended to attach the property, and the wrongful act of the defendant has prevented him from executing this intention. On the whole, it does not appear that the tort of the defendant caused any damage to the plaintiff, but even if so, yet it is too remote, indefinite, and contingent to be the ground of an action. Many cases might be cited to the same general effect. In an action on the case for conspiracy which arose in Rhode Island, the plaintiffs, who were simple contract creditors, claimed that the defendants and the debtor had combined together to prevent plaintiffs and other creditors from obtaining payment of their debts, that the debtor, among other things, had made fictitious mortgages to the defendants under cover of which the latter had secreted the property and removed it out of the debtor's possession, so that plaintiffs were prevented from attaching it, and had thus lost their claims. The court ruled that the action could not be maintained. A simple conspiracy, says Nelson, J. in Hutchins v. Hutchins, however atrocious, unless it resulted in actual damage to the party, never was the subject of a civil action, not even when the old form of a writ of conspiracy, in its limited and most technical character, was in use. Yet authority can be cited tending to uphold a recovery in such cases. In Meredith v. Johns, it appeared that an action of tort had been brought, and a verdict for £500 rendered, against a third party for secretly and maliciously taking, carrying away, and concealing the slaves and property of one Peter May, and also for aiding, assisting, and counseling May to absent himself, to the end that the creditor might be prevented from recovering against him. The Supreme Court of Appeals of Virginia declined to interfere in equity to restrain the enforcement of the judgment, and took the position that the defense was a legal one, and that the party aggrieved must seek redress in a law court. It seems, however, to have approved the procedure. The case of Quinby v. Strauss, of which the reports are meager and unsatisfactory, is another illustration. The action was instituted by judgment creditors of one of the defendants against such defendant and his attorney, charging them with having fraudulently conspired together to keep the debtor's personal property out of the reach of his creditors by the execution of chattel mortgages thereon to secure fictitious debts, one of them to the attorney, under which the property had been sold and bid off in the attorney's interest. The property so sold exceeded in value the amount of the creditor's judgment. The jury found that there was a conspiracy, and the judgment was upheld, the appellate court saying that as the property appropriated by the attorney to his own use exceeded in value the amount of the creditor's claim, it was but just that he should pay the creditor whose demand he had sought to defeat. The point that nominal damages only could be awarded was expressly overruled. The recovery in this case must, however, be rested upon the ground that the attorney had a sufficient amount of the debtor's property in his hands to satisfy the complaining creditor's claim. In such a case, the rule that only nominal damages are recoverable is not controlling. SS 62A. Reference not ordered. In New York State, an action to set aside a fraudulent conveyance will not be referred. Gilbert, J. said, references are proper only as aids to facilitate the transaction of business. The growing multiplication of them within the last 15 years has been an evil prolific of individual injustice and public alarm. SS 63. Relief collateral to main action. The rule is established in New York that in surplus money proceedings in a foreclosure suit, the referee has the authority to inquire as to the validity of liens or conveyances, and they may be attacked as fraudulent. In a reference as to title and partition, a party can assail a mortgage held by another party on the ground that it is fraudulent and void as against creditors. It is asserted that no good reason exists why the fraudulent character of conveyances cannot be tested in such proceeding. When the jurisdiction of equity is once acquired, the court has the right to proceed to the end and administer complete justice between the parties. This practice is considered more convenient for the disposition of cases of this character, and avoids the tedious process and increased expense incident to a distinct and separate action instituted for that purpose. Again, actions in aid of an execution at law are ancillary to the original suit, and are, in effect, a continuance of the suit at law to obtain the fruits of the judgment or to remove obstacles to its enforcement. Usually the titles of adverse claimants cannot be litigated in foreclosure. SS 64. Remedy governed by Lex Fori. In a case already cited which arose in Massachusetts, it was said that the law of New York respecting fraudulent conveyances was the same as the common law and the law of Massachusetts, and that although choses in action could not be attached or levied upon in New York, yet after execution issued on the judgment at law, such interests might be reached by supplementary proceedings. While in Massachusetts these kinds of rights were subject to trustee process, the court said that the assignment having been found by the judge, before whom the case was tried without a jury, to have been made in fraud of the plaintiff, as a creditor of the assignor, and being under the law of either state voidable by creditors in some form of judicial process, the question whether it should be relieved against on the common law or on the equity side of the court was a question of remedy only and governed by the Lex Fori. It may be observed that the general rule that the Lex Fori governs the remedy controls the right to arrest the debtor. Thus, where goods were sold in New York on credit to parties who transacted business in Alabama, and the debtors subsequently disposed of their property in the latter state with intent to defraud their creditors, the New York Supreme Court held that an order of arrest was properly issued against the defendants by that court. In Pritchard v. Norton, the court said, the principle is that whatever relates merely to the remedy and constitutes part of the procedure is determined by the law of the forum, for matters of process must be uniform in the courts of the same country. But whatever goes to the substance of the obligation and affects the rights of the parties, as growing out of the contract itself, or inhering in it or attached to it, is governed by the law of the contract. It is foreign to the scope of this treatise to discuss at length the question of how far a transfer of personal property, which is lawful in the owner's domicile, will be respected in the courts of the country where the property is located, and where a different rule as to transfer prevails. This is a question upon which the courts are much at variance. It must be remembered that there is no absolute right to have such a transfer respected in the foreign forum, and it is only on a principle of comity that it is ever allowed. And this principle of comity always yields in cases where the laws and policy of the state in which the property is located have prescribed a different rule of transfer from that of the state in which the owner lives. SS 65. Cumulative remedies allowed and disallowed. We have disclaimed the consideration of Frand in the light of a crime, and entertain no design of noticing the penal statutes enacted for the punishment of fraudulent insolvents or their co-conspirators. This subject more legitimately appertains to a treatise on criminal law, and is a matter regulated by statute. Sometimes resort to the penal statutes conflicts with the pursuit of the civil remedy. In a controversy which arose in Maine, it was decided that one who had commenced an action to recover the penalty provided by the revised statutes of that state for knowingly aiding a debtor in the fraudulent transfer of his property to secure it from the creditors, waived his right to prosecute his suit by filing a petition against his debtor and having him declared a bankrupt, and then causing a suit to be commenced against the alleged fraudulent transferee by the assignee in bankruptcy, to recover the value of the property alleged to have been fraudulently transferred. As to civil remedies, it was decided in Michigan that where a judgment creditor had elected to treat as fraudulent a conveyance made by his debtor before the judgment, and, notwithstanding the transfer of title, had proceeded to sell the property on an execution, he could not afterward maintain a bill in equity to set aside the conveyance. The logic of this ruling is scarcely apparent. Again, a creditor who has instituted an action at law for the recovery of a debt and levied an attachment cannot, before judgment, bring a second suit to recover the debt, annul an alleged fraudulent judgment recovered against the debtor, and restrain its collection. In New York, on the other hand, a complainant may institute supplementary proceedings and prosecute a suit to establish his judgment as a lien upon real estate. He may prosecute either or both proceedings until his judgment is satisfied, so he may bring a creditor's action to remove a cloud upon title, and also sell the debtor's land under execution. And in Massachusetts, a remedy is given by statute, which enables a creditor to maintain a bill to reach equitable assets, without having previously recovered a judgment at law, and without admitting other creditors to join in prosecuting the suit. It was decided that this remedy was not superseded by the grant of general equity powers. SS 66. Effective imprisonment of debtor. It may be considered as settled law that while the creditor has the body of the debtor in execution on a cause, his right to proceed against property is suspended. So long as the defendant is in custody, the creditor cannot file a bill in chancery to reach his equitable assets. This rule proceeds upon the theory that the arrest and imprisonment of the debtor constitute a satisfaction of the judgment during the continuance of the imprisonment. SS 67. Election of remedies. In Cone v. Hamilton, the Supreme Court of Massachusetts said it had been decided in that state that levies of executions in favor of creditors passed no title where, at the time of the conveyance which was before the Stat. of 1844, c. 107, took effect, there was no statute by which land paid for and occupied by a debtor, the legal title to which had never been in him, but had been conveyed by his procurement to other persons in order to secure it from his creditors, could be attached or taken on execution at law as his property. Gray, J. Continuing, said, upon this state of facts, either of two remedies was open to the judgment creditors, the conveyance being fraudulent as against them, the parties who took the legal title paying no consideration for the conveyance, and the equitable title being in the debtor who paid the purchase money. The judgment creditors might doubtless have maintained bills in equity to charge the land with their debts, or, it appearing that the land cannot be held under their levies, they might, by sire facies, have obtained new executions on the original judgments. It does not, however, follow that this bill can be maintained in its present form. The plaintiff has acquired no interest in those judgments, or in the debts on which they were recovered. The only transfers from the judgment creditors, under which she claims, are quitclaim deeds, without covenants of warranty, of the land taken on execution, which, as the grantors had no title, passed none. Those creditors are not made parties to this suit, either as plaintiffs or defendants, and would therefore be at liberty, notwithstanding any decree therein, to pursue their remedy by sire facies against their debtor. It would be inconsistent with the principles and the practice of courts of equity to maintain this bill, upon the ground that the original conveyance was fraudulent and void as against the judgment creditors, without making them parties to the suit in due form. It may be further observed that a judgment creditor is not obliged to follow all the fraudulent conveyances which may have been made by several execution defendants, but may leave some of them to stand while he seeks to set aside others. Nor can the debtor or the fraudulent alienee, as a general rule, compel the creditor to elect which method of procedure or class of property he will pursue. SS 68. Creditor's bills. It is said in New York that the object of a creditor's bill in that state is to reach choses in action and equitable assets of the judgment debtor which cannot be reached by execution, and, before such a bill can be filed, it is always necessary that an execution should be issued to the county where the judgment debtor resides, and be returned unsatisfied, and in such an action all the judgment debtors are necessary parties, unless it can be shown that one omitted is insolvent or a mere surety for the defendant. The filing of a creditor's bill and the service of process, as we have said, creates a lien in equity upon the effects of the judgment debtor. It has been aptly termed an equitable levy. It may be here observed that a creditor's bill, in many of our states, is an appropriate remedy to annul a conveyance and fraud of creditors. It ought always to be resorted to where this latter relief is desired. A creditor's bill is the continuation of the former controversy. So far as the fruits of the judgment are concerned, the complainant asks the aid of the court to reach the assets of the defendant, so as to be made liable to his judgment, which assets have been secreted or fraudulently assigned to defeat the judgment. Usually creditors' bills are largely regulated by statute, and the relief extended is often in a measure dependent upon the local laws governing the subject. It may be asked in what respects a creditor's bill differs from an ordinary bill in equity, prosecuted to cancel a covenant conveyance or remove a fictitious transfer. The answer is that the creditor's bill, at least in some states, is broader and more effectual in its operations and results. The ordinary bill or suit in equity is generally brought to unravel some particular transaction, and to annul some particular conveyance, or remove a cloud on a particular title. A creditor's bill, on the other hand, is usually in the nature of a bill of discovery, and is more extended in its results. Not only does it reach property described therein, but by means of this form of remedy every species of assets, and even debts due the debtor of which the creditor knew nothing, and which were not referred to in the bill, may be reached through the instrumentality of a receiver, and applied to the claim. For this reason it is appropriately called an omnibus bill. Creditors' bills, says Mr. Bispam, are bills filed by creditors for the purpose of collecting their debts out of the real or personal property of the debtor, under circumstances in which the process of execution at common law could not afford relief. This equitable remedy may be made use of during the lifetime of the debtor, or after his death. Creditors' bills filed against the estate of a decedent, generally, though not necessarily, partake of the nature of administration suits. SS 69. Direct and collateral attack. Exceptional doctrine in Louisiana. A novel principle relating to covenant conveyances, derived from the civil law, prevails in Louisiana. If a sale is fraudulent as to creditors, it must be regularly set aside in a direct action or proceeding instituted for that purpose. Not only is it binding between the original parties, which is the universal rule, but it is conclusive upon third parties until nullified by the form of action which the law provides, and the possession of the vendee is legal until the fraudulent instrument is avoided in the due course of law. The reasons for this practice are ingeniously given in Pete v. Morgan, by Porter, J., who there says, of its correctness the court entertains no doubt. It is clearly supported by authority, and it is sanctioned by reason and utility. The principle on which it rests is that men are presumed to act honestly until the contrary is proved, that the conveyances alleged to be fraudulent are prima facie correct and fair, and that it is improper in opposition to these presumptions, the creditor should exercise rights that could only properly belong to him, in case the acts of his debtor were null and of no effect. In many instances, should a contrary doctrine prevail, sales which were alleged fraudulent might turn out to be bona fide, and the purchaser be deprived of the use and enjoyment of property which was honestly his, in the uncertainty which must prevail until the matter undergoes a judicial investigation. It is certainly the wisest course, and the one most conducive to general utility, to consider the thing sold as belonging to him in whom the title is vested. It is idle to speculate as to the utility of this doctrine, for it is entirely opposed to the general practice in the other states, and to the English and American authorities. The fraudulent transfer is not generally regarded as being effectual against creditors. It does not as to them divest the debtor's title, but his interest remains subject to their remedies, and may be seized and sold on execution. The property may be treated and reached by creditors as though the transfer had never been made. Thus in Imre v. Magne, the court said, it is now of frequent occurrence that the sheriff is bound to take goods which have been fraudulently conveyed or assigned to defeat creditors, and is responsible in an action for a false return at the suit of a creditor. Though the principle embodied in these Louisiana cases may seem logical and fair upon its face, certainly its practical operation would not be commensurate with the needs of creditors generally. The creditor cannot be expected to lay formal siege to every semblance of an obstruction that the debtor rears in his pathway. The theory concerning a fraudulent conveyance is that it has only the color and appearance of a valid act, and is not in itself effectual. Why then should the creditor be forced to undergo the vexatious delay and expense incident to procuring a formal adjudication vacating every covenant alienation of property which the ingenuity of the debtor may devise if the transfer is in fact fraudulent? Then, by seizing and selling the property on execution, the controversy is practically concluded without further trouble or suit, and the fraudulent alienee will not be rash enough to attempt to reclaim it. On the other hand, if the transfer is bona fide, the creditor is legally accountable for the seizure. If the creditor unjustly refuses to treat the transfer as valid, the purchaser, if it relate to realty, may hold the possession and defend an ejectment, while if it be personalty, he may recover it by replevin or sue in traver. In either case, If the vendee claims the property, indemnity would be exacted by the officer making the seizure. Under the Louisiana system, a debtor, by selecting an irresponsible vendee, could shield him with a simulated transfer and enable him to dissipate the property in practical defiance of the creditor. SS 70. Forms of relief in cases of fraud on wife. Special treatment of the relationship of husband and wife as bearing upon fraudulent transfers will be found in the body of the work. We may allude here to the rule that where a husband has fraudulently alienated his real property, as against the rights of his wife or prospective wife, she may, even during his lifetime, bring suit to annul the deed as a fraud upon her right of dower. For an inchoate right of dower is an interest which the courts will protect. It is as much a fraud for a man to place his property out of his hands for the purpose of avoiding the right of dower which is about to attach to it, as it is for a debtor who contemplates the contraction of debts to voluntarily dispose of his property in order to defeat the efforts of future creditors to secure their payment. The latter result, it is conceded, as elsewhere shown, cannot be successfully accomplished. The wife may in such cases maintain a bill in equity to reach the property fraudulently conveyed. Or she may, according to some of the cases, file a bill in chancery to recover her dower in the property as though no conveyance had ever been executed. SS 71. Procedure in federal tribunals. Statutes passed by state legislatures affecting rights of creditors, being local enactments and involving a rule of property, the federal courts will adopt the construction which has been given to the statutes by the highest judicial tribunal of the state, even though, were it an open question depending upon the general principles of jurisprudence, the conclusion of the court might have been different. A federal court is bound to apply such a rule of property precisely as though it were sitting as a local court in the state, and this is true as to the observance of a state rule governing voluntary conveyances, general assignments, or sales rendered void for want of a change of possession. And sometimes relief may be had in a federal court where the jurisdiction of the state court would have proved imperfect. Where a state court acquires possession and control over an insolvent debtor's property, it has power to dispose of it and to give a good title. To this extent, as against a federal court, the state law is a rule of property, where a creditor's suit is removed from a state court to a federal court on the ground that the controversy is between citizens of different states. Jurisdiction is not lost by admitting as plaintiffs other creditors who are citizens of the same state as the defendant. As we have shown, the local law where the property has its situs governs in controversies to reach such property by creditors. It may be here observed that leave to sue and defend in forma pauperis will be accorded to infants in the federal courts, though a different rule prevailed in the state tribunals, and that equity jurisdiction in the federal courts is wholly independent of the local laws of the state, and is the same in its nature and extent in all the states, and that federal courts are bound to proceed in equity causes according to the principles, rules, and usages which belong to the courts of chancery, as contradistinguished from common law courts. Questions as to appellate jurisdiction in federal tribunals will be presently considered. SS 72. Recapitulation. As regards the enforcement of a judgment against real property fraudulently conveyed, a creditor then may be said to have three modes of obtaining satisfaction of his demand. First, to obtain a decree of a court of equity declaring the conveyance fraudulent, setting it aside, and thereafter proceeding to sell the land on execution. Second, by inserting in the decree an equitable action, in addition to the provisions avoiding the transfer, a further clause appointing a referee to sell at public auction and directing the debtor to unite in the conveyance, or a clause appointing a receiver and directing that the debtor convey the land to him and that he sell it. Third, the creditor may sell the land on execution, and the purchaser may then set up the fraud in the debtor's conveyance, and if this is established, obtain a judgment entitling him to the possession of the land. The advantages incident to a judicious selection from these remedies in particular cases should not be overlooked. Stated in a form of more universal application, it is, as we have seen, a familiar and unquestioned doctrine of equity, that the court has power to aid a judgment creditor to reach the property of his debtor, either by removing fraudulent judgments or conveyances which obstruct or defeat the plaintiff's remedy under the judgment, or by appropriating toward the satisfaction of the judgment rights or equitable interests of the debtor, which are not the subject of legal execution.